We'll take it out from there, and we follow in the order in which we introduced ourselves earlier. That the Constitution of Kenya 2010 is a transformative one has never been in dispute at all. Its implementation has, however, not been without considerable challenges, mainly because of competing interests among three categories of Kenyans: the holders of political power, aspirants for political power, and the majority of Kenyans who are apolitical and whose foremost interest is to see that all the affairs of this country are well handled, irrespective of who rules political power. The Constitution declares that all sovereign power belongs to the people of Kenya and shall be exercised only in accordance with the Constitution. The people of Kenya have delegated their sovereign power to Parliament and legislative assemblies in the county governments, the national executive and the executive structures in the county governments, and the judiciary and the independent tribunals. The judiciary has been given constitutional mandate to arbitrate political, social, and economic disputes among the people or among the three arms of government. It is required to do so by way of diligent and honest interpretation and application of the Constitution and the laws of the country. These appeals are basically about interpretation of three articles of the Constitution, 255, 256, and 257, that form Chapter 16 of the Constitution. The appeals arise from the judgment of the High Court sitting in Nairobi, dated 13th of May 2021, in Constitutional Petition number E282 of 2020, consolidated with 7 other constitutional petitions, numbers 397 of 2020, E400 of 2020, E401 of 2020, E402 of 2020, E416 of 2020, E426 of 2020, and 2 of 2021. Each of the petitioners challenged various aspects of the Constitution of Kenya Amendment Bill 2021, hereinafter the Amendment Bill, and the process that preceded the crafting of the bill. The background is as follows. On 9th of March 2018, President Uhuru Kenyatta and the former Prime Minister Raila Odinga, who had come out of a bruising presidential election contest, decided to bury their political differences that were evidently causing considerable discord in Kenya and came together with the aim of uniting the country. In a symbolic handshake, the two leaders set in motion various events that were aimed at moving the country forward. The President and the former Prime Minister released a joint communique known as Building Bridges to a New Kenya Nation. The communique contained 9 issues that affected our country, and these are ethnic antagonism and competition, lack of national ethos, inclusivity, devolution, divisive elections, safety and security, corruption, shared prosperity, and responsibilities and rights of citizens. In order to address the identified issues, on 31st of May 2018, the President, by Gazette Notice number 5154 of 2018, appointed the Building Bridges to Unity Advisory Task Force, the BBI Task Force thereafter, to document and recommend practical policy and administrative reform processes that would build the country's lasting unity and the implementation modalities for each identified challenge areas. The terms of reference of the BBI task force were as follows. A, evaluate the national challenges outlined in the joint communique of BBI to a new Kenyan nation, and having done so, make practical recommendations and reform proposals that build lasting unity. B, outline the policy, administrative reform proposals and implementation modalities for each identified challenge area. And C, conduct consultations with citizens, the faith-based sector, cultural leaders, the private sector, and experts at both the county and national levels. The BBI task force visited all the counties in Kenya and collected views from more than 7,000 citizens from different ethnic groups, community leaders, religious institutions, to name just but a few. On 26th of November 2019, the BBI released its report on what is known as, quote, building bridges to a united Kenya from a nation of blood ties to a nation of ideals. In short, it's referred to as the BBI Task Force report. On the following day, the report was unveiled to the public, and the public public engagement thereon kicked off. The BBI Task Force report came up with various policy and administrative reform recommendations which enabled constitutional amendments, policy reforms, statutory enactments, institutional reforms, as well as behavioral and ethical changes amongst the citizens. To actualize their foresaid recommendations, the President, by Gazette Notice number 264, dated 3rd January 2020, and published in a special issue of the Kenya Gazette dated 10th of January 2020, appointed a steering committee known as the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force report. The mandate of the steering committee was twofold. Number one, conduct validation of the BBI Task Force report through consultations with citizens, civil society, faith-based organizations, cultural leaders, the private sector, and experts. And two, propose administrative, policy, statutory, or constitutional changes that may be necessary for the implementation of the recommendations contained in the BBI Task Force report, taking into account any relevant contributions made during the validation period. The BBI Steering Committee held a number of stakeholder consultation meetings and received memoranda from members of the public and organizations, and on 21st of October 2020 presented its report known as the Report of the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force report. The report recommended various constitutional, legislative, policy, and administrative measures. The BBI Steering Committee also came up with a draft Constitution of Kenya Amendment Bill 2020. The recommendations made by the BBI Steering Committee and the draft Constitution of Kenya Amendment Bill 2020 were viewed by various stakeholders and members of the public as unconstitutional for various reasons that I will highlight hereafter. To accommodate those concerns, some amendments to the draft bill were made, and the final Constitution of Kenya Amendment Bill 2020 was printed by the government printer on 25th of November 2020. The aforesaid amendments did not stop various petitioners from moving the High Court in 8 petitions to challenge the process by which the amendment bill was formulated and the contents thereof. They argued that they were unconstitutional. The following petitions were instituted. Number 1, petition number 2, E282 of 2020, David D. and others versus the Attorney General and others. 3 main issues were raised in this petition, namely, A, whether the legal and judicial doctrine of the basic structure of a constitution, the doctrines of constitutional entrenchment clauses, and amendable constitutional provisions, and constitutional amendments the theory of unamendability of the Constitution, essential features in our Constitution, and the implied limitations of the amendment power in our Constitution are applicable in the Republic of Kenya. B, whether Chapter 1 on sovereignty of the people and the supremacy of the Constitution, Chapter 2 on the Republic, Chapter 4 on the Bill of Rights, Chapter 9 on the Executive, and Chapter 10 on the Judiciary, and the provisions therein form part of the basic structure, entrenchment clauses, and eternity provisions of the Constitution, and therefore cannot be amended either under Article 256 by Parliament or through popular initiative under Article 257 of the Constitution. And C, whether taking guidance from the doctrine of the basic structure of the Constitution, the constituent power, and the doctrines of unconstitutional constitutional amendments, the limits of the amendment power in the Constitution, and the theory of unamendability of the eternity clauses, there is an implied or implicit limitation to powers of constitutional amendments under Articles 256 and 257 of the Constitution. Dr. Duncan Oburu Ojwang, Dr. John Osogo Ambani, Dr. Linda Andisi Musumba, and Dr. Jack Musalile Mwimali, law professors, were admitted as amici curiae, and they advanced similar arguments as the petitioners in petition number E282 of 2020 regarding the basic structure doctrine, the limits of the constituent's power, and the role of the courts in interpretation of the Constitution, among others. Number 2, petition number 3E397 of 2020, Kenya National Union of Nurses versus Steering Committee of BBI and others. The petitioner urged the court to determine whether the task force on building bridges to Unity Advisory Committee was duty-bound to include an independent and constitutional health service commission in its October 2020 report. The petitioner sought 3 orders. 1, a declaration that the omission of the petitioner's proposal for an independent and constitutional health service commission in the October 2020 report of the task force on building bridges to Unity Advisory offends Articles 10, 27, 41, 43, and 47 of the Constitution of Kenya, and the task force on building bridges Unity Advisory be compelled to publish a fresh amendment bill to include the same. B, a declaration that the IEBC be prohibited from conducting the preparatory process towards the approval of the amendment bill and submission of the same to a referendum. C, an order that Parliament be restrained from receiving and passing the amendment bill. The third petition was E400 of 2020, Third Way Alliance Kenya versus Steering Committee of BBI and others. The substantive issue raised by the petitioner was whether a popular initiative for the amendment of the Constitution of Kenya can be commenced by state actors, in particular the President of the Republic of Kenya. The petitioner further argued that a popular initiative in the amendment of the Constitution cannot be commenced and undertaken without a legal framework for the same. The petitioner sought the following reliefs. A declaration that the Constitution of Kenya Amendment Bill 2020 was not a popular initiative towards the amendment of the Constitution of Kenya. B, a declaration that there is no legal framework to undertake an amendment by way of a popular initiative, to wit, collection of signatures and their verification and conduct of a referendum. And C, a declaration that county assemblies have the power to amend the amendment bill, do not have the power to amend the amendment bill. Number 4, petition E401 of 2020, 254 Hope versus the National Executive of the Republic of Kenya. The petitioner herein urged the court to determine whether the national executive or any state organ or entities can commence a popular initiative for the amendment of the Constitution of Kenya and utilize funds in the initiation and pursuit of the process. It is sought the invalidation of the entire process, resulting in the publication, approval, and passing of the amendment bill. The fifth petition was number E402 of 2020, Justice Juma and Isaac Ogolla versus the Attorney General and others. The petitioners raised the question whether the creation of 70 constituencies by the by the promoters in the amendment bill was unconstitutional, since the function of delimitation of the constituencies is vested in the IEBC. They urged the court to declare as unconstitutional and annul the creation of the 70 constituencies in the amendment bill. The sixth petition was number E416 of 2020, Morara Omoke versus Raila Odinga and others. The petitioner raised the following issues. A, whether the Constitution of Kenya Amendment Bill 2020 can be submitted to county assemblies for consideration, tabled in Parliament for passing or rejection, and transmitted to a referendum in the absence of a legal framework for facilitating the same. B, whether the amendment bill can be transmitted to a referendum before a nationwide voter registration exercise. And C, whether the use of public funds by the President and Honorable Raila Odinga in the initiation and facilitation of the process culminating in the tabling of the amendment bill in Parliament is unconstitutional. And D, whether Parliament has power to act upon the amendment bill following the declaration of its unconstitutionality for want of enactment of the 2/3 gender laws and the advisory opinion by the Chief Justice to the President for its dissolution. The petitioner prayed that the court declares as unconstitutional and invalidates the entire process culminating in the publication of the amendment bill. Petition number 7 was E426 of 2020, Isaac Alucher versus Uhuru Muigai Kenyatta and others. The substantive question raised by the petitioner was whether the President has power to initiate an amendment to the Constitution of Kenya in the manner relating to the amendment bill and to use public funds in such a process. He contended that the steering committee had converted an illegal presidential constitutional change initiative into a popular initiative. He sought a declaration on unconstitutionality and the invalidation of the entire process. Worthy of notice is that this petitioner sought certain declarations against the President in his personal capacity. And the last petition was number number 2 of 2021, Muslims for Human Rights, Muhuri versus Independent and Electoral Boundaries Commission and others. The main contention by the petitioner was that the IEBC cannot undertake verification of signatures and registered voters without an enabling legal framework in place, and sought a declaration to that effect. I'll now summarize the responses to these petitions. The Attorney General filed grounds of opposition, raising a total of 12 grounds, which I shall summarize as follows. He stated that a declaration that the Constitution, the provisions founded under Article 255(1) of the Constitution forms the basic structure, entrenchment clauses, and eternity provisions of the Kenya Constitution and cannot be amended under Article 256 of the Constitution or through a popular initiative under Article 257 of the Constitution would be against the express provisions of the Constitution, including Article 255(1), which will have been rendered odious. He added that the petition did not meet the established legal threshold of justiciability for want of ripeness, that the interpretation propounded by the petitioner runs contrary to the constitutionally prescribed purpose mode of interpretation by negating express purposes of Articles 255, 256, and 257 of the Constitution, and that any comparative analysis of foreign jurisprudence could not be used to either contradict or supplement the text of the Constitution of Kenya, that the petitioners were invoking an advisory opinion jurisdiction which the High Court cannot give. The Speaker of the National Assembly, who was the second respondent, raised 9 grounds of opposition. He concurred with the arguments advanced by the Attorney General with regard to justiciability and ripeness. In addition, the Speaker of the National Assembly contended that the petitioners were preempting how the National Assembly would exercise its mandate with respect to the amendment bill, and that the issues advanced could have been tabled before Parliament during public participation exercise as envisaged under the Constitution of Kenya 2010 and the standing orders of the House. The second respondent further argued that the High Court lacked jurisdiction to intervene in active parliamentary processes, and therefore any challenges to the amendment bill had to await the completion of the legislative process before the jurisdiction of the courts can be invoked to challenge the bill. The Speaker of the Senate, who was the third respondent, also filed grounds of opposition, raising 8 grounds. He reiterated the grounds argued by the Attorney General and the Speaker of the National Assembly. He stated that the people of Kenya have the sovereign right to amend the Constitution in the manner prescribed under Articles 256 and 257 of the Constitution. On their part, the BBI Secretariat and Honorable Raila Odinga filed consolidated grounds of opposition, raising 10 grounds, most of which were a replica of the grounds raised by the first, second, and third respondents. They also filed an affidavit that was sworn by Mr. Dennis Waweru, who stated that he was one of the co-chairpersons of the BBI Secretariat and its co-chairman was Honorable Junet Mohammed, that the Building Bridges Initiative was created and mandated with the task of initiating a constitutional amendment process and unifying Kenya, among other functions. Mr. Waweru deposed that Article 1 of the Constitution of Kenya 2010 vests sovereign power to the people of Kenya, and such power is to be exercised only in accordance with the Constitution of Kenya 2010, that the Constitution is not a rigid document, and pursuant to Articles 255, 256, and 257, it can be amended as provided for in the said provisions, that if the framers of the Constitution did not intend that the Constitution be amended, nothing would have barred them from having such an express provision included therein. Regarding the doctrines and theories of basic structure, constitutional entrenchment clauses, and unamendable constitutional provisions as proposed by the petitioners, Mr. Waweru stated that they were mere theories and hypotheses only applicable in different jurisdictions and relevant depending on the special circumstances of each jurisdiction. The IEBC contended that in the exercise of its powers under Article 257, it enjoys constitutional and administrative, decisional, and financial independence, that it carried out its constitutional mandate of verifying that the constitutional amendment initiative was supported by at least 1 million registered voters, that it was erroneous for the petitioners to argue that there was no legal framework for verification of registered voters, as the provisions of Article 257 made it possible for the actors to know their obligations, and therefore there was no basis of making any finding against it. For making any finding against it. In respect of the petition by Mr. Isaac Aluchir challenging capacity of the President to initiate a popular initiative for amendment of the Constitution, the President did not respond to the petition at all. However, the Attorney General filed grounds of objection, stating in the earlier that the President Uhuru Muigai Kenyatta cannot be sued in his personal capacity